guys. So I want to say thank you to everybody who voted in my Instagram story poll that they wanted the case summary of the latest Queensland court decision about superannuation, and particularly whether an attorney under a power of attorney can make a binding death benefit nomination. So yes, you guys voted in favour of a case summary, so I've put one together. Bear with me, I'm using my notes because this case has everything, okay? It's called Re Narumon Proprietary Limited by the Supreme Court of Queensland. It has it all. We've got blended families, we've got the scope of power of attorney, financial decision making, whether attorneys can make binding death benefit nomination or renew one under a power of attorney, conflict of interest, invalid binding death benefit nominations in the format, because we're nominating non-death benefit dependents, whether a deed of variation was valid, lost pension documents, 3 years lapsing. It literally covers everything. So for practitioners who are not in Queensland, there's still some really, I think, useful principles coming out of this decision. There is, however, some very specific guidance about the scope of the Queensland Power of Attorney Act and how that applies. So just try and extract the principles that you need to, but when looking at the conflict of interest requirements for the power of attorney and whether an attorney document can be used to make a binding death benefit nomination, you will probably have to translate some of the principles to your specific jurisdiction Power of Attorney Act. Okay, so you will have noticed an edit there because I just had to go and Google how to pronounce Giles. So hopefully I've got it right now. So what actually happened in this case? So Mr. Giles died at the ripe old age of 80, and he left a wife, Mrs. Giles, and together they had a 16-year-old son. Mr. Giles also had 4 children from a previous relationship who are now adults. Another key player in this case is his sister, Mrs. Keenan. So there was a self-managed super fund, which is really the centre of this case because all of his wealth was left in the self-managed super fund. The estate itself had about $200,000 and that was it. In the self-managed super fund, we had a pension of $3 million, which was alleged to be reversionary back to Mrs. Giles, and then an accumulation count of $1 million. So we got $4 million in play. And the real issue is what to do with those benefits, because in Queensland, the challengeable pool would only be limited to what comes into the estate. So that's about $200,000. If the super comes into the estate, then obviously the pool will go a lot further. If the super goes directly to beneficiaries straight from the super fund, then that's all not up for grabs. So one of the adult daughters had challenged the estate, brought a family provision application. At the time of bringing the application, Mrs. Giles was the sole director of the self-managed super fund, and she wanted guidance on what to do because we had issues around reversionary pension and binding death benefit nominations. So our first issue that we're going to cover off, and I will actually just go through these in the same order that the court went through them rather than order of importance. So the first issue was whether the deed of variation that Mr. Giles had signed back in 2004 was valid. So this is a pretty benign issue, but it's actually super important because if we're interpreting the provisions of the self-managed super fund deed, we need to know which set of rules to rely upon. So in 2004, Mr. Giles, he was the sole director of the corporate trustee then, signed a deed of variation as authorised representative. Now, he should have signed it as sole director and secretary under the Corporations Act. 7 years later, the auditors had picked up that he had signed as authorised representative, not as sole director and secretary of the corporate trustee, and they arranged for a deed of ratification to be prepared. Now, the original deed of variation did a wholesale replacement, updating the terms of the deed, and the ratification just said, well, actually, when he signed, he was the sole director and sole director and secretary. So even though it didn't say that in the deed of variation, he's ratifying it now. So The issue was whether we could rely on the terms from the 2004 deed of variation and the ratification. And the court held, yes, that was okay. So that's not a huge issue, but I mean, it's really important that the trust documentation is done correctly and by a lawyer, because these types of issues are a distraction, and if you've got to go to court to have them approved and get an order, then you've already lost, right? The second issue is around the pension. So it was understood that the $3 million pension was a reversionary pension back to Mrs. Giles, but nobody could find the pension documentation. So they had to go back 18 years to when it was set up, and no, they just couldn't find any of the establishment documentation. So I bet that the advisors were sweating and trying to find back all their files to see if they could actually come up with anything. The best they could come up with was some supporting correspondence and just financial statements evidencing the reversion. So the court ultimately found there was enough circumstantial evidence to be comfortable that it was a reversionary pension back to Mrs. Giles. But guys, this is a $3 million question. So what's the key learning? If you've got reversionary pensions, make sure that you have a record of all the documentation. If you're advising on them or making assumptions as an estate planning practitioner, I think it's prudent to check that the documentation is there and it's established, and we're not just assuming it, because the fact that about 3/4 of the fund is subject to a reversionary pension, which takes priority over the BDBN. Really important outcome in this case for Mrs. Giles. The next issue is about the BDBN. So there's $1 million in the accumulation account. Between 2010 and 2013, Mr. Giles had made 5 BDBNs. Some were updated like 2 months apart. And basically, he just kept changing the percentages. So the very first one in 2010 was 100% to Mrs. Giles. In 2012, he went 40% to Mrs. Giles, 40% to their son together. The balance 20% between the sister and the 2 of the 4 kids. A year later, he updated it to go 44% to Mrs. Giles, 44% to their son together, and 12% to the legal personal representative, aka the estate. So the last 2 nominations are more relevant. So in 2013, he updated it to say 47.5% to Mrs. Giles, 47.5% to his son with her, and then 5% to his sister, Mrs. Keenan. And then 6 weeks later, he made the exact same nomination, but it was held to be a nomination that would lapse after 3 years. So it was going to lapse in June 2016. Okay. First issue, Mrs. Keenan is not a death benefit dependent. She wasn't financially dependent. So the 5% to her, invalid. We've got a problem. Mr. Giles had lost capacity by 2016. So when the nomination lapsed, it was up to his attorneys. So for financial matters, Mrs. Giles and Mrs. Keenan were his joint financial attorneys in Queensland. They did a couple of things. Firstly, they renewed the binding death benefit nomination that lapsed with the 5% to Mrs. Keenan, and then they also made a new binding nomination that went 50-50 to Mrs. Giles and her son. So they acknowledged that the 5% to Mrs. Keenan would be invalid and updated it. Mrs. Keenan also did a disclaimer of her 5% in that BDBN. Few issues. The first issue, really like a random issue, was the BDBNs were not in the same form as prescribed in the deed. So we'd established that the 2004 deed was the correct terms of the super fund. So one of the issues raised was it didn't comply with the requirements of the BDBN. So the deed said the BDBN had to be, it may be in the form in Schedule E or in accordance with any regulations that apply to the fund. So a couple of things. Firstly, the judgment goes into quite a detailed analysis about whether the SIS regulations actually apply to a self-managed super fund. So if you're interested in that, have a read. It goes through relevant judgments and interpretation of the rules, but effectively they held the SIS regulations do not apply to self-managed super fund. So it did not have to comply with the SIS regulation format for a BDBN. Secondly, the court held that because the technical wording of the clause around BDBN said may comply with the form in Schedule E, it did not have to. So it didn't matter that it didn't comply. So I think we're really lucky there about it coming down to the word may instead of must. Guys, I think the learning here is if you're not a lawyer, don't put yourself at risk by drafting BDBNs for SMSFs, because it really does turn on the minutiae on making sure the BDBN complies with the SIS deed. And if you are involved, make sure you comply and read the SIS deed. Don't just use your template form. Make sure it is actually going to be compliant. The more important issue, I think, focuses on whether as attorneys they had the scope to renew and make the binding death benefit nomination. So I'll mention a few things. Firstly, the super fund deed did have a power allowing a member to delegate their powers and rights under the deed to attorneys. So the super fund allowed a member to delegate to an attorney, but it didn't specifically say you could delegate a BDBN. It was just a general one. The issue is looking at the Queensland Powers of Attorney Act. So the power of attorney was just an attorney for financial matters, and it did not expressly say that the attorneys could make or renew a BDBN, and it didn't say that they could act in a conflict of interest. And we've got a clear conflict of interest between the entitlements of the attorney, particularly Mrs. Giles, and the BDBN, because the attorneys are receiving a benefit under the BDBN. So in the Queensland Power of Attorney Act, attorneys cannot act in a conflict of interest unless expressly authorised. And there's also restrictions on attorneys making testamentary dispositions for the donor. So you can't, as an attorney, make a new will or a power of attorney. So the court considered whether the renewal and the making of the BDBN were actually allowed under the definition of financial matters in the Queensland Power of Attorney. So if you are a advisor or practitioner in a state that's not Queensland, you're going to have to refer to your local state Power of Attorney Act and look at what the authorisations are there and extrapolate the guidance here into those provisions, because this is Queensland specific, okay? So firstly, on the issue of whether a BDBN can be made by an attorney, they said yes, you can actually make, it is okay. It's a financial matter, it's not prohibited. But we then had a second issue around conflict of interest. So what the court held was that the renewal of the BDBN that Mr. Giles had made, which went 5% to the sister and then the balance 50% to Mrs. Giles and her son, the renewal was not a conflict of interest transaction and it was okay. And that's because it was just confirming something that Mr. Giles himself had done. But the making of a new BDBN 50-50 to Mrs. Giles and her son and cutting out Mrs. Keenan was a conflict of interest because one of the attorneys was getting a benefit, total conflict of interest, and he held that it was not a valid BDBN. Okay. So this could have all been avoided by including in the power of attorney an express provision allowing the attorneys to act in a conflict of interest and also expressly authorising them to renew and make a new BDBN. So I personally like to include this in all powers of attorney I make. Now there's a little asterisk there because in Western Australia, for landgate purposes, that will probably get you a requisition, but in every other state, it's really worthwhile doing. Now, overlaying that is making sure you include the appropriate safeguards and checks and balances for the attorneys to make sure that they're not given too much power, because we don't want an abuse of power. My preference is to include those express authorizations for the attorney to have expanded authority beyond the restrictions in the attorney legislation, and then have the right checks and balances at the attorney level. But obviously with a blended family, you really need to give this a lot of careful consideration. Now, another issue is what happens with the 5% of the super entitlement in the BDBN to Mrs. Keenan, because that was held to be an invalid nomination. She wasn't going to satisfy a death benefit dependent nomination as a sister. So it is actually up to trustees' discretion to decide where that 5% goes. And we've got another issue here because Mrs. Giles was one of the executors of the estate, and she's the sole director of the corporate trustee of the SMSF, so it was up to her discretion where that 5% goes. But she would have had a conflict of interest because as the executor, her duty is to maximise the estate, i.e. pay the super benefits into the estate. So she had actually taken advice on this and renounced her entitlement as an executor, so that as sole trustee or sole director of the corporate trustee, she had unfettered discretion. So that's another important reminder of really taking careful consideration when you're choosing who is going to be controllers of a self-managed super fund and an executor. So what are the key takeouts from this case? Firstly, if you are an advisor assisting clients with super fund administration or a legal practitioner, make sure and do an audit that all of the trust documentation is there, including your reversionary pension nominations, your BDBNs, and that everything has been validly executed. If you're a financial advisor and accountant, I just do not think it's worth the risk for you to be getting involved in preparing any of those documents, because they're legal documents, so don't do deeds of variation, changes of trustee, BDBNs for self-managed super funds. The risk is too high, and as you can see from this case, the details do really matter, especially when there's a dispute and it's blended family. I personally think all powers of attorney should include express authorizations that attorneys can act in a conflict of interest and also make and renew BDBNs, but just be very cautious around who is appointed as attorneys so that you have the right checks and balances there. I also think it's really important to update the super fund deeds. So this could have all been avoided if we didn't have to worry about renewing that lapsed BDBN after 3 years. So self-managed super funds can have BDBNs that are non-lapsing. Depends on the terms of the deed. It needs to say that the BDBNs can be non-lapsing. But if that had been the case, then we wouldn't have had to consider the issue of whether the scope of the power of attorney extended to renewing or making a new BDBN. So this is a really exciting case. I definitely think it's worth reading. It's not that long. What is it, like 30 pages or something. It's got a really detailed analysis of the case law and the regulations in the SIS Act and how they apply or don't apply to self-managed super funds. So I think it's a really good case worth reading. And even if you're not in Queensland, there's some good principles that can come out and apply to your practical application when dealing with clients. So another thing I'll just mention, we've got the Art of Estate Planning Facebook group. It's a space for like-minded advisors who want to share their insights, learnings, keep up to date with what's going on in this space. So if that's of interest to you, look it up in the Facebook search, the Art of Estate Planning, send in a request to join, and we'd love to have you in that community as well. Thanks for watching. Have a great day.